into problem. So I personally, my personal take on this is just like the Indonesian's law. Do not use nominee agreement. I repeat that again, do not use. But again, I am not in a position to tell you what to do or what not to do. I'm here only displaying what is what. It's again all up to you to decide what you want to do. Ladies and gentlemen, this is Luisa Turnip from Jakarta. Today I've got some hot topic to discuss with you. It is nominee agreement. Yes, ladies and gentlemen, we will talk about nominee agreement, and you are welcome to participate. That comment section below this video is for you. So drop your thought, your opinion, or your questions if you have any. First of all, let me introduce myself. My name is Luisa Turnip, and I am a corporate lawyer in Indonesia, based in Jakarta, but we also travel around in Indonesian Republic territory. So now, without further ado, let's dive right into it. So nominee agreement is a hot discussion and topic. I found it also curious whether or not people actually know what nominee agreement is. Why there are still many people using this scheme. So speaking from my own experience working in law firm, we have several clients who are dealing with land dispute, and that dispute come from nominee agreement. And in same time, we also have foreigners who are about to enter into trouble, into problem. They want to buy land using nominee agreement. And I think, like, do you really know about this? I maybe know why they want to use it actually for this particular three answer. Mainly they want to own land or property or boat or share investment, and to circumvent a certain law and a regulation. And if they're lucky, then everything goes good. But life, unfortunately, does not work like that. So we have people who are already in trouble and in problems, and we have people who are about to enter into problem. So I personally, my personal take on this is just like the Indonesian's law. Do not use nominee agreement. Yeah, I repeat that again. Do not use. But again, I am not in a position to tell you what to do or what not to do. I'm here only displaying what is what. It's again all up to you to decide what you want to do with that, with these informations here. So let's define what is nominee. Indonesian's law, which is come from civil law system, we don't have such nominee agreement. Indonesian's law doesn't directly recognize these terms. It's something that comes from common law. However, with the principle of facta sunt servanda, which is saying literally the agreement that made by parties are becoming constitutions or law that regulate the relationship between the parties that concluded in that agreement. And so with that, if you analyze that logically, so if you make any agreement, so suppose that that agreement is going to be legitimate, binding, and enforceable. Yes, that's true. But here's what Indonesian law says about it, which is 4 elements that what makes binding and legally enforceable agreement, and that regulated in Indonesian Civil Code, third book, Article 1320. 4 elements will determine either that contract is going to be legitimate or not. Subject requirement must be that parties must give consent. The parties that are involved in that agreement must have consent. No coercion, no force, and from free will and clear mind. And then number 2, still on subjective requirement, that parties involved in that agreement must be by law are competent. Obviously, yeah, in Indonesia, being competent according to Indonesian law, they must be 21 years old or can be younger and married. And subjective requirement, that, and this how this nominee agreement in conflict, yeah. So nominee agreement in conflict with this, that the object in the agreement must be not in conflict with law and regulations in Indonesia. So what is the object? Land. So what Indonesian's national law says about land? According to agrarian law, that Indonesian people, the one are entitled for freehold right. And objective requirement number 4, still around on the objective requirement. Also, what makes nominee agreement void and null? That the object is for admissible cause. So if we look at that, admissible cause means come for good faith and for good reason. While if we look, the nominee agreement is the purpose of nominee agreement. So what is nominee anyway? Okay, according to Black Dictionary law, it defines as one is designated to act for another, to represent another in a limited sense. In other words, there is one borrowing one's name and use that name under that person's name in order to get land, property, boat, yacht, let's say, and so on and so on. So why do usually people use that? It's for this usually for main, this is the usually main reason. One, they want to keep privacy or to keep private on the real owner, and that's for reason, right? That law should be company, which is in Indonesia regulated by law, company law, there has to be transparency, it must be opened, right? But with nominee, so it's because they want to keep their privacy. So the owner doesn't want to be visible player in that company that they're running in overseas or offshore. So instead, they find local nominee and let them the one operating the business. Number 2 is usually for the reason number 2 oh my god, I sound like very rigid, like my usual way, but okay, anyway. So reason number 2 is because they want to get some cut with tax. And for in Indonesian case, usually because they want to circumvent, to get around the law in order to get benefit or advantages from the small gaps of the law. So here there is restrictions or limitations for foreigners, for example, with investment or owning freehold land right in Indonesia. So if we look at that, the Indonesian Civil Code, third book of the 1320. So clearly that four element is what determine either or not the agreement will be valid. So we can see where is the flaws, where is the mistake, why that agreement is void and just cannot be enforced, has no legal ground. So that is the problem. When there is dispute occurred between parties, which is the beneficiary and the nominee, then the beneficiary does not have legal standing. So how do we usually cope with that situation? If we take it to court, obviously, there is no legal ground. Per schema or a decree that issued by Supreme Court. Supreme Court, that was, if I'm not wrong, in 2020. Yeah, in 2020. That according to nominee, the name that written in certificate, that is the legitimate owners of that land. So let's say foreigners use my name with their money, with their asset. The land, since that registered on my name in the certificate, it's all belong to me. And here's the funny part. Some people believes and suggest by notarizing this nominee agreement is going to give power into the nominee agreement, which, I'm telling you this, rather disappointing, is not. It's still the same, illegitimate and null and void. So literally, that agreement doesn't change any form or doesn't add any power to it, despite witnessed by notary or signed or giving stamped. Because let me give you this analogy, kind of like this: you have dirt in your body and make bad smell. When you put perfume, is that smell automatically disappeared, gone? No, right? So it's just the same with this agreement. It's the formations of that agreement, the nature of that agreement is just wrong. It's not compliant with law and regulations, which is what just been described by the ICC code of that 1320. Yeah, I guess there are many people involved into this kind of scheme simply because of ignorant. They're not being told what is what. So hopefully this video give you some more insight and give you some knowledge so you know how to navigate and to conduct, make a good decision. So that's my take about this nominee agreement. So if you want to purchase land and you want to have property, just go with that safe way. You don't have the eternal land like the Indonesian ones, let's say, but at least you have legal standing. Anyway, if lease is much cheaper, if you get that, maybe you can have 2 pieces of land instead of buying the freehold one. So yeah, what else? So anyway, I think I want to talk also about, can foreigner then buy land and lease land, yeah, obviously, and can pass it into the heir. So if you happen, in the event of death occurred, yes, that can possibly be passed into the heir. However, it must be following the law and regulations, which is the kitab. There is a permit and still valid, the state permit that can make your heir eligible to get the inheritance. I think that's all. Is there anything else? And if you do, please have that comment section, drop in there. And if you want to have one-on-one discussions with me, I'm more than welcome. Thank you very much, and I will see you on my next video. And hang on, don't forget, give me likes, please, and also subscribe, and have a wonderful day.